All right, Eric, you can probably get us started.
Sounds good. Good morning, everyone. We'll call the meeting to order. Aaron, do you want to take a roll call?
Yes, thank you. Good morning, everybody. Representative Seconder,
Here.
Director Strauss,
Here.
Senator Harvey, no, Senator Noland,
Here.
Senator Zolnikoff, Representative Etchart. Representative Teal could not make it today. I just see Dr. Harrington just came on for Director Brereton, sitting in for Director Brereton today. Stacy Anderson.
Here.
Tanner Avery. Webb Brown.
I'm here, but I'm on the Board of Dentistry call as well, so I'm just monitoring. Thank you.
Thank you. Representative Buttry will be late today, and Jennifer Hensley cannot make the call. So Troy Jensen,
I'm here.
Tony King, no, Alan Lloyd,
Here.
Brad Longcake,
Here.
Krista McCauley,
Here.
Amy Narrison,
Here.
Allison Paul,
Here.
and Jason Small.
Here.
Great. Okay, I think that is everybody. For staff today, I'm Erin Sullivan with the Department of Labor and your staffer. We have, oh, it's light for staff today. Lisa Patzer, our fearless technology leader. And I think that's it. I don't see Quinlan on the call yet, and I don't see Kevin either. So just the two of us, but we'll make it.
All right. Thanks, Aaron. So we'll move on in the agenda to our first item for discussion. I'm hoping that everyone had an opportunity to read the policy memo that Aaron provided us that detailed some recommendations for each of the policy areas that we've been interested in up to this point. I think the goal today is to recommend some specific policy suggestions regarding that memo. So with that, Aaron, do you want to share that memo? Is that the easiest way to go through it?
Yeah, that'd be, I can easily do that. Um, and yes, as Director Strauss mentioned, well, you all are aware that we have our meeting in Billings on Monday, and so the idea is to have, oh, I'm on the wrong thing, sorry. To have a couple of these recommendations if these ones are pretty well fleshed out. And so they don't have to be perfect. If you've been on the other subcommittees, but we do want to be able to have a couple for the task force to review and hopefully move forward with refining for the final report. And so that's really the purpose of this discussion. And then the following discussion, there was also some policy options, and if you guys are ready to move forward with those, that's great. But these ones are definitely ones that are pretty close, I think. So, did you want me to review the memo, or do you want to just dive in?
I figured we just dive in. I think we can go kind of item by item. That would be my preference, anyways, unless someone objects. Um, I think I think each of these has been pretty well fleshed out in conversations. So I think it's just a matter of um, us deciding which direction we want to go. So just procedurally, Aaron. So I know, do we need to take a vote on a recommendation as a subcommittee, and then that would be the process for advancing it to the full task force?
Yes, Mr. Chair, thank you. So what the other subcommittees have done is, this is a task force, and so, it's not a formal votes, but they have made a motion, someone's made a motion, and then, if there's been disagreement or discussion, then they've talked about it. But yeah, it would be just a, kind of a moving forward motion or instruction for me um, to develop the recommendation.
Okay. So the first one for us to review as a subcommittee then is the question of good moral character. And Aaron, I don't know if you could provide maybe just a little background again, just a quick snapshot of what that's about, and then maybe just a quick overview of what the three recommendations are for that one.
Sure. Thank you, Mr. Chair. So, on the screen, you can see that I have the good moral character standards. So this is just a little matrix and it shows that there's three options. This is all based on the last meeting that we had. So basically, there is broad concern that good moral character requirements are undefined, inconsistently applied, subjective, all of that. And so there was a talk at the previous meetings of should we just get rid of the good moral character standards in all of the statutes that are relevant? Do we need to define it? Do we need to clarify it somehow? And then someone had brought up the point that, well, maybe it's a requirement in compacts, and there's at least one example that I know of where it's a requirement federally. And so it can't just be a blanket removal. That was kind of the consensus. And so the ask was for me to come up with some options for you on one, to remove it where possible, two, to define it and narrow it where it is retained, or just leave it to the boards, because I believe that was one of the committee members' comments was this should just be a board decision. This shouldn't be a task force decision. So option 1A is to remove the good moral character requirements where it's not federally required. And so I did put some pros, cons, and considerations under each of these. But this one would be to recommend legislation removing any good moral character language from licensing statutes unless we come back and say, no, this is mandated by federal law or a compact obligation or accreditation or something. And so we don't want to take those out if they absolutely need to be in, but where it's not federally required or otherwise through an agreement, then remove those good moral character requirements. The second one, option 1B, is retain only where there's actually value added and define it. So there was a lot of discussion about putting it in definition, and there's a couple states that have done this, either for related to their licensing for criminal offenders. I think that's Michigan. Al and Lloyd was nice enough to provide a couple definitions like specific with CPAs that talk about what good moral character actually means. So that's an option. We could define it and apply it to the relevant requirements within whatever, I can't remember. I think there's like 15 or so occupations that have this as a requirement. So it could focus on objective or profession-related conduct, such as whether the applicant has engaged in conduct that has a direct and substantial relationship to the duties and public protection risks of the profession. It might consider rehabilitation, time elapsed, mitigating circumstances, all those types of things. And so there's pros and cons and considerations. I think if the committee decides to move forward with this, I don't think that you have to actually come up with the definition today. I think we still have time. And again, all of these recommendations need to be agreed on consensus-wise with the full task force. And so we could use just this as the recommendation. And then the task force, the other members of the task force can provide input on what else should be included. And then we can come up with a definition at the next meeting. Or I think we have two more meetings after this. And so there is time, so don't feel pressured that you don't want to pick this one if this is the one you want, because we don't have a solid definition. And then the final one is do nothing. So this is no broad statutory change, leave a good moral character to board discretion. And so if you don't like the first two options, if you think the board should just handle this, then this is your route.
Thank you, Aaron. So maybe I'll just open up the conversation from my perspective. I think we should do something. I don't think C is the right path for this task force. I personally lean towards A, where I just think there's too much subjectivity in the standard and too much. It's too easy to kind of work around and can be abused from the licensing body's perspective. So I just think there's too much ambiguity in the kind of the moral character requirements. Having said that, obviously, if we went with option B, we could provide some more structure and definition there. But those would be my preferences and would open it up for discussion. Mr. Lloyd.
Thanks. I too think A is the option I prefer. And Aaron, just take a deep breath. I'm not gonna go nuts. Uh, I think my only issue with A is on the list of cons, the last item there is does not itself resolve how boards should evaluate troubling non-criminal conduct. And Aaron and I had an email exchange yesterday because to me, troubling non-criminal conduct is a nebulous, undefined term that is probably worse than good moral character, in my humble opinion. And I think the line of thought that this drove for me is I think the question of boards considering non-criminal conduct is one that has some value to it. I think that again, just not having clear definition for the board around what they should and should not use as things to take action, to me is the core of the problem we're trying to address here.
Thank you, Mr. Lloyd. Ms. Paul.
Um, Chair, thank you. I'm in support of 1A. I'll make mine short.
Ms. McCauley.
Yes, thank you, Chair. I would agree, just 1A. I think that I was either 1A or 1C, but I really was not in favor of B, and I think 1A is the better route. Thank
Mr.
you.
Jensen.
So is this something that would affect all boards, every single board? Is that what we're talking about here? Aaron?
Yes, Mr. Chair and Mr. Jensen. So the option 1A is to recommend legislation removing the good moral character requirement unless it is federally required or through a compact or something like that. So we would
Specifically, the Board of Professional Engineers and Professional Land Surveyors would no longer have a good moral character type of requirement.
correct.
So I'm definitely against 1A. That is not a good thing for our board. We do not have a background check requirement. So this is the only thing we have is this good moral character requirement. So I would be a 1C, do not change, I guess, or else 1B would be the only way to go. I mean, this has some large repercussions on other boards besides some of the medical field. And I think that it's too broad of a stroke that has substantial effects to multiple boards that are say the non-medical field boards that I don't think folks realize. A lot of boards do not have background check requirements that may feel in their in their experiences, assuming that all boards have background checks and stuff like that. They don't. A lot of boards do not have background checks. So this is the only thing that we have is some moral character, some references, some stuff like that. So I definitely am fully against 1A. So that's my thoughts on it. Thank you.
Thank you, Mr. Jensen. Mr. Brown.
Can you hear me?
Yep.
I'm trying to mute the Board of Dentistry in the background and jump on here. Sorry. It may have indicated in the past support for eliminating them and in consultation with our folks. They are the same as Mr. Jensen. They would prefer 1C or 1B, but not 1A. Thank you.
Senator Nolan.
Thank you, Mr. Chair. Now, I'm going to come at this a little different. When we look at, from legislative standpoint, and there's because we hear of certain people that come before my committee anyway, and they say, well, this hasn't happened. Then I've gone into some court issues in listening to the court cases, and the judge says there's no direction. So it's ambiguous. It's open. It's free. So they pretty much get to decide what they want to do. Now we're talking about boards. So my concern with A and C, so I'm in favor of B, is if we don't have something for somebody to look at and say they're reading through it and say, well, yeah, I can accept this. I can belong to this. Something that's simple as moral character should have something to say, oh, I guess I better be more careful, bring it out, and then get it resolved if I have an issue so that they can be in good standing with a board. So that's where I'm at. Thank you.
Thank you, sir. Ms. Anderson.
Thank you, Chair. I appreciate the conversation so far. I think I would support 1B, certainly providing a definition in statute and then going board by board to see if it's relevant and supported by the board and the related association to either retain the good moral standing requirement or if it's something that can be removed.
Thanks. Aaron, did you have something?
Yes, thank you, Mr. Chair. So I think if I could just provide a little bit of additional context, I guess, for this discussion. So one thing that was shown at the last meeting, Kevin Bragg, he went through the personal history questions and the attestations that are included in an application. And so the application process is kind of like the first opportunity, obviously, for a new applicant to say, yes, I have, had this unprofessional conduct or a discipline on my license or, those types of things. And so that's the first filter, and that wouldn't go away. And that's really where this bullet point that says, this isn't gonna change how that process goes. For the definition, once you put a definition in statute, then that's it. There's no other interpretation of it. And so one thing that you could consider if you wanted to do a definition is to have the boards really specify what it is. So I would just be a little cautious about putting a very, strict definition in because like we were saying with the, what is it? Where is it at? The, direct relationship. And so something that would be considered immoral character for one profession may not really apply to the other. And so I think that, if you do the definition, I really would encourage you to say that it has to have a direct and substantial relationship. And that is going to be a board by board thing or profession by profession. The other thing that you could consider is I just glanced through for Mr. Jensen's comment. You guys don't actually say good moral character, you ask for letters of recommendation. So those are two different things. And so I don't think that, and you could actually restructure it again to Webb's comment on the Board of Dentistry. They ask for affidavits of good moral character. So that's actually kind of both. It's a letter of recommendation and, a good moral character requirement in one. So it could be revised. Some of these terms could be revised to say that it's a letter of recommendation instead of you have to have good moral character. I think that's the sticking point is that just what is that? That means something completely different to me than it does to another person. So just a couple of things for you to consider as you go through your discussion.
Thanks, Aaron. Dr. Harrington.
Yeah, thank you, Chair. I don't want this to be taken wrong, but we're trying to remove obstacles to licensing. And I'm involved in recruiting a lot of people, and I have never had this come up as an obstruction. to licensing somebody. And I think the point about the questionnaires is really important because it does kind of address this. And trying to define something like this, as Aaron pointed out, is real challenging, especially with the spectrum of different licenses we're looking at. And so my bottom line point is I think there are things that are more of an obstruction than this is, and I would prefer to leave it up to the individual boards to address it rather than try and define it and put restrictions that maybe are unnecessary. So that's just my opinion. Okay.
Thanks. Mr. Jensen, did you have something else?
Sure. Thank you, Chair. So so what I've seen happen on the for our board, it does fall under letter of recommendations, and this particular item, I've heard staff make recommendations of removing letters of recommendation from our application process, and this falls under that, and so I believe this would be a way to remove the letter of recommendation requirement. And so I want to avoid that as much as possible because the letters of recommendation are a vital part of the application process and a vital step in the future licensees' um, growth as a professional. And so our board, you know, is fully supportive of keeping the letters of recommendation. And so that's where I'm coming from, is that if this 1A was recommended from this task force, then the letters of recommendation, from what I've understood staff, would go away. And so that's why I I I hear you when you say that they're probably two different things, but that isn't what I've heard. Department of Labor staff, they lump them together. And so I guess I would recommend 1C, leaving it up to the boards to 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 maybe define or understand how to use good moral character. So thank you.
Thanks. Representative Seconder.
Thank you, Mr. Chair. I'm slightly concerned that if we go with option 1B, what we'll ultimately end up with is option 1C. That my colleagues in the legislature this will get bogged down with, and just the process will end up killing it. I mean, we talk about how we have a 90-day session, but something like this has to move in 45 days. And I think everybody on business and labor is going to have an opinion on this, and a bunch of 2-word amendments to define moral character. I think option 1A is a lot more straightforward. Also, option 1C requires 0 legislation. So, in my opinion, it's one of the two. This attempt at a definition seems like a fool's errand to me.
Thank you, sir. Ms. Paul, did you have something more?
Chair, yes, I just wanted to say that I'm actually probably more in agreement with Mr. Jensen than you might think from my earlier comment. I'm making a distinction between what's in the statute, just like Representative Seconder just said. I think I would, so there's different between removing it from the statute and then letting the boards decide. Those two things I think can go together because I think, but I mean, I would like a opinion of a Department of Labor lawyer, but if you remove it from the statute, and I agree we should not try to define it, I think that's a morass. But if we remove it, we're not federally required. I would think it opens it up so the boards could do what they need to do. Aaron, do you have an opinion on that?
Thank you. And then for the record, I am not an attorney. So I just want to make
Yes,
that clear.
sorry, I knew that.
No, that's fine. I think that, yeah, maybe in the interest of time, what we will do a staff analysis. That's what this, really this is to come back and say, these are all, there was that chart that I provided at one of the very first meetings that said, these are all the statutes where it says good moral character. And not letters of recommendation. That was a separate one. That I think you're right that that is kind of the board's discretion as to, what is that letter of recommendation look like, and and that could be in rule, but where we would probably come back and say, okay, for I have just construction blasting up right now. For construction blasting, all it says is of good moral character, and so the intent would be to remove that vague term. But those personal history questions that are on every single application do allow the board to say, hey, this could be a red flag. And so we would want to review that further. If they answered whatever question it was that said, maybe I am of not of good moral character, or I have done something that I'm trying to hide, then that could, get escalated for further review by the board or the screening panel, I guess. I don't know if I answered your question. But it's not like we would say that it's totally up to Department of Labor to determine, unless it's the real estate appraisers, where I know that there's a CFR that says it has to be in there. We're gonna cut it all out, and we do a ton of stakeholder outreach and engage with all of the boards, and they would be well aware of this and be able to provide their feedback as well. And so that's just part of our process.
Thanks, Aaron. Mr. Lloyd?
Yeah, I just as staff look into that, the question that remains in my head is how do we provide clarity both to the board members who have to make these decisions, but then also to the applicant so that they know going in exactly what is and is not an issue. I think one of the other things that I would ask the group to consider is if we're applying some requirement, that requirement be the same standard that current licensees are held to. I know one of the options that I think I know that CPAs have, I don't know if everybody has, is a code of conduct. And so if licenses, hold their licensees to a code of conduct, applying that same code of conduct to initial applicants could be a methodology to ensure that everybody's treated in a fair, consistent manner.
Thanks. So my perspective on this is that there's a bit more work to do and not a clear consensus around a recommendation. I think we can have that as a report out on Monday, to say that there's still dialogue and maybe there'd be some additional feedback from the whole task force on a direction that we perceive might be more amenable to the entire group. So that'd be my recommendation on this particular item, is that we just bring forward this discussion, a little bit more work to do, and not a clear recommendation on the direction we want to take at this point. Is that fair? Anyone object to that?
Sounds good.
Aaron did instruct me that we had to come up with some recommendations today. So 0 for 1. Sorry, Aaron.
Okay, I gave you an idea. So before we move on to the next topic, so would you like me to include these three, like these pages for discussion on Monday?
Yeah, I think we can use
Okay.
that and then use that as just a means by which to give a perspective for the whole
Okay.
committee on what our thoughts are.
Okay. You want me to keep going?
Yes, please.
Okay, so the next one has to do with background checks and multiple licensures. So there was a lot of discussion about background checks and that being a kind of a bottleneck or an administrative burden, just the time to get your license because you're waiting on a background check. And so we I was asked to put together at the last meeting, Representative Buttry mentioned that he wanted to review the alcohol and cannabis license statutes because they have an allowance for I think 5 years. So once you have your background check done, then you can apply for another license and use that same background check. And so this is so and then we also talked about maybe instead of each individual practice act having its own background check statute, having one standardized one. And then so I think those are the two options. And so right here is option 2A. So this would be similar to what is already in the MCA for other professions or businesses, but allow reuse of background checks for additional licenses within a defined period. So we would craft a statute that would allow an applicant who's completed the background check for a Montana occupational license to rely on that for another DLI administered license for a defined period, and we had discussed 5 years. If they're remain in good standing and then they attest that they have no disqualifying criminal charges or anything like that, then they wouldn't need a subsequent background check. And so again, pros and cons. And this really had to do with, I think it would most apply to and address the barrier that was identified in behavioral health. So if you start off, you get a candidate license and then you do some more supervision or something like that. I don't know the licenses that well. And then you'd be eligible for a full one. And so if it was within that 5 year period, then when you go to get your full behavioral health license of whatever kind it is, addiction counseling or social work or whatever, then you wouldn't have to go through that background check again. Cons are that, a 5 year period may be too long for some high risk professions, and it does rely on self-reporting and attestation, which can be imperfect, I guess. But that self-reporting is already in statute, and so if you have a license and you get arrested for something or whatever, you are supposed to report that to the board anyway. So some considerations if you go with this option is what the period of time should be: 5 years, 3 years aligned to board renewal cycles. However, it was mentioned that background checks are not required upon renewal. And I think renewal cycles are like annual. Hugh is on the call, luckily. If I mess any of this up, Hugh, just raise your hand and correct me, please. Option 2B is to create a centralized background check framework in Title 37. And these could actually be incorporated together. And so if you just want to do the reuse then 2A is just concerning that reuse option. 2B, you could roll that in if you like this option as well. And so this is a general Title 37 background check statute that's applicable to all DLA licensed administered boards. This was attempted in 2023 with the department's really big bill that didn't pass. And so this thought has been around with the department for a while, just to standardize the background check framework. And then the statute would identify any of the covered professions and define timing. It could authorize reuse, preserve some exceptions, and standardize applicant attestations and board authority. So here, this is a consistency thing. Instead of going into each of the individual practice acts and trying to figure out, does this license require a background check, and what's the process? This would be just all in one provision in the general Title 37 provisions. We do have to make sure that we avoid any kind of conflict, and also keep the compacts in mind. And so I think a recommendation would be to have a savings clause in this for the compacts, and so there isn't any question that changing this over to a standardized process means that you don't need a background check for a compact. So that's that option. And then the last option is no broad background check statute and do targeted board by board cleanup. And so this is just more of a board decision type approach, again, similar to the good moral character requirements.
Thank you, Aaron. Again, I'll just open it up quickly. I think either A or a combination of A and B makes a lot of sense. I don't know that 5 year is the right number or not, but that's certainly something that could be debated and discussed. I like the idea of universal background checks. I think if it's good for one, it's good for all, but I don't know what that does to process necessarily for the licensing professionals. So having said that, open up for comment. Representative Buttrey.
Thank you, Mr. Chair. I'll agree with you. You kind of took some of the words out of my mouth. I think that standardization of that background check framework is important, as stated in 2B, but I also think that we need to address the issue of folks with multiple licensure and having to go through that standardized process over and over. So I support a combination of 2B and 2A. I'm fine with the 5 years, but I think, we'd want the department to weigh in on that. I'm also interested in a way that we can extend that background check across different boards or agencies. That might require some statutory work to allow departments to share that information that those checks have been completed and passed. But I think we can absolutely help remove barriers to licensure across multiple agencies and boards if we implement that time frame, standardize, and then allow boards and agencies potentially to share that data. Thank you.
Thank you, sir. Dr. Harrington.
Yeah, thank you. I am in violent agreement with both you and Representative Buttrey. The only concern, I think a combination of A and B would be absolutely great. The only concern I have is the 5 years because that might be specific to the particular license type. And maybe if we could leave some flexibility in that area for the individual board. But again, I'm fine with it as it's worded here, but that was just a nuance I was concerned with. So 100% on board with your suggestion.
Thank you, Doctor. Any other comments, questions, concerns? This one didn't strike a nerve as much as the last, apparently. So, all right. I mean, with that, unless there are other comments, I guess, make a motion to have the subcommittee adopt a recommendation that includes components of 2A and 2B to recommend to the full task force for consideration. So maybe just keep it simple at the beginning is to do the 5 year recommendation there and then have a centralized and standard background check framework for all of Title 37.
I second.
Any discussion? All right. Hearing none, maybe we could just do a voice vote. Does that work, Aaron? Mm-hmm. All in favor of that, say aye.
Aye.
Aye. Aye.
Opposed? All right. 1 for 2, Aaron. We're rolling now.
Great. Thank you, Mr. Chair. Thank you, committee. So I will come up with a short recommendation summary for presentation on Monday, and I'll likely put a couple of the just talking points about the years, how many years, 3, 5, or different frequency, and also if it could be extended, if there's appetite for it to be extended outside of Title 37. So I will work on that, and then great, we can move on. So number 3 had to do with provisional licensure, temporary practice. And so we did have a conversation at the last meeting about what happened in 2025 with our, I think it was HB 414 that had to do with license applications. And so we created a new statute that kind of lays out provisional licensure and temporary licenses. And so so that is in place already. There was, I think, a little bit of discussion from the Licensing Bureau on whether or not the boards were actually utilizing this. And that does tie back into the background check thing. I think that was the biggest thing. But for a provisional license, the board can grant a provisional license if you're missing, if you're just missing one thing, like if you're waiting on an exam score or something, or you still need to take the exam, and but everything else is all done, then you can get a provisional license pending the result of that exam. Or the background check. But for temporary practice, I think there maybe was a little more discussion and there could be a little more opportunity for this. So right now, the temporary license that is in place or is available is just it's for like certain scenarios, and so like continuity of care if you're coming in to provide education, um, and treatment to an underserved population, or highly specialized treatment, I think. And so I think there were four things, and you can get up to 21 calendar days per year if you have that. And then if you're going to practice, outside of that, then you need to go ahead and get a full license from the board. So some options for these, and so I think this was more of like administrative barriers. So options, you could recommend board review and use of existing provisional licensure authorities. So recommend each board and program review the rules and consider using provisional licenses when an otherwise qualified applicant is awaiting background check results. And I think for this one, if that's what you want, again, this wouldn't be a statutory change. It would just be a recommendation for the department to work with the boards to ensure that this is being implemented to its fullest extent, I guess. Option 3B is adopt a default provisional license pending a background check. And so this would just create some clearer statewide policy. Let's see here. What does this say? Create a default provision that they may issue it to otherwise qualified applicant. Yeah, when a required background check is pending, unless prohibited by law or compact requirements. And so that would probably be amending. Sorry, I'm just trying to think on my feet here. That would probably be amending the HB 414. I can't remember what that MCA is, but just amending that to further clarify that a background check, you have to provide a provisional license pending a background check. The other option is to revisit the temporary license framework. And so, and again, you don't have to come up with actual ideas, but this would be, if you want to move forward with this one, just is this temporary framework too restrictive? But do we need, or can we add some opportunities for people to come in and practice on a temporary basis without having to get a full license outside of what is currently in statute? Or is 21 days too short? Should it be 28? I don't know. So that's just, those are the options regarding provisional and temporary licensure. I seem to recall that everybody was pretty okay with these, with the statute that was passed last session. But there could be some specific opportunities just to kind of tweak it.
Thank you, Aaron. I'll open it up again. Just from my perspective, I think certainly a encouragement from the department towards the boards to leverage their provisional authority makes a lot of sense. If it's not being done, there should be some accountability there for those that are maybe not leveraging it as much. Additionally, I would be supportive of a provisional grant during pending background check. And then on the 21 day, I don't really have a perspective on that one. Certainly entertain other thoughts from the subcommittee. But that would be, I think, certainly adoption of A and B makes a lot of sense from my perspective. Any comments? Dr. Harrington.
Yes, thank you, Chairman Strauss. Yeah, I agree with you. The only variation I would suggest is on option 3C, because we have these experimental treatment centers coming in where 21 days might not be long enough for follow-up, that maybe we suggest a revision to allow that to be renewed on an ongoing basis with review, pending a permanent license or something like that, just to not limit it to 21 days for some of those ETCs. That's not a problem for this year because those probably won't be around until next year, but it's just a thought. Okay.
Thank you, Doc. Ms. McCauley.
Hi, yes, thank you. I was on the same boat with extending the 21-day thing and the 21-day provision. And I do think that it's gonna be somewhat dependent on what license we're talking about and what kind of practice we're talking about. So I do think that um, it needs to be more board specific, perhaps. And considering the extension of 21 day, uh, I don't know if that's consecutive or 20 determined, and I think we need to clarify that, or rather extend it and open it, because I do think that there's ways for continuity of care, not just for like these this testing that Dr. Harrington referenced, but also like for telehealth and people who seek care outside of our state for specialty care. I think that this we can make this much more um, conducive to continuity of care by extending those days or broadening that. Thank you. If I made any sense.
Any other comments, questions? All right, seeing none, I would offer a motion then to recommend A, B as presented in this document, and then maybe with C with just some additional context for there to be more consideration on a board by board perspective to understand the impacts on that before moving forward with a full recommendation on expanding the 21-day framework.
This is Kristen McCauley. I'll second that motion.
Any discussion? All right, try voice vote again. All in favor, say aye.
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 Any opposed? Great. Thank you. Moving on. Aaron.
Thank you. Thank you, Mr. Chair. Thank you, committee. So I will develop recommendations I will probably, well, no, I'll do them separate. I guess we'll see how it goes. For 3A and 3B. And then for 3C, I guess just a clarification, would you like us to provide a little more analysis before even talking about it at the full task force, like maybe at the next meeting? I can come up with a little more and we can have a deeper discussion on that. You still will have an opportunity for additional recommendations at the final meeting. And so I think there's plenty of time if you want to, flesh this out within yourselves instead of at the full task force meeting.
Yeah, unless there's objection, I'm fine with that. And I would say maybe we can just mention it as part of the report that this is also under consideration.
Yeah, okay, that's great. Okay, and then the last one on this has to do with we had a brief discussion at the last meeting about portability, compacts, and all of that. And I am getting all of my meetings confused. And I recall I was very sick at the last barriers meeting. And so I don't know if this is one that when Kevin talked about like what the difference between a reciprocity agreement and a compact is. But I think everybody should be pretty well aware of all of the different terms and everything. Oh yeah, so there was an overview of portability terminology. So at the last meeting, this subcommittee, they did express general support for compacts as a workforce and portability tool. And there was a mention of boards endorsing compacts or developing compacts within their associations and stuff. And so I remember that was on there. So I think there are a couple of these. So based on all of those discussions, option 4A is adopting a general statement supporting interstate compacts and board-led compact review. So instead of having a separate recommendation for each of the compacts that are available, this would be just that if a compact is available, the subcommittee recommends supporting it, that Montana supported as a portability tool, and that the boards are involved in that decision. So this, I think, would apply to the healthcare subcommittee is already putting forward a recommendation for the EMS compact and the social work compact. And so I don't really know if it needs to be also recommended here, but this would be there is like a podiatry compact that the Board of Medical Examiners is interested in. I know there's more. And so I'm trying to think of the other ones. Oh, there's cosmetology compact. And so that hasn't been discussed at any other subcommittee because that's kind of, that's not one of the bucketed occupations. And maybe someone's sending me a lifeline. No. So I can't remember. There's a few other ones that, athletic trainers is one. The dentistry one, I just remembered now that, that Webb raised his hand. So this would be, instead of saying this committee recommends that we go forward with the podiatry compact and then a second recommendation that says the dentistry one, this one is more just a general support for interstate compacts. And I have the list somewhere. I just don't have it in front of me. Option 4B is just kind of going into that conversation that was the last at the last meeting between reciprocity, universal licensure versus compacts and all of that. This is just preserving what's in place now, which is the substantial equivalency framework, and deferring any kind of universal licensure expansion. I think that came up in public comments, as well as just a general understanding of all the different portability tools available. This would just be what's in place now is good, and so basically say no to universal licensure. And then the other one in this section for portability is reduce duplication where national certification supplies the core qualification. So this goes into a lot of the conversations that we had about certifying entities, and are there professions where all you need is a registration, a national certification, or something like that. So an occupation by occupation review that rely of statutes that rely heavy on national certifying, accrediting, or testing entities, and where it can be done, recommend removing either removing the state license, converting it to a registration, or streamlining the application. And so we're not duplicating a bunch of efforts here. I think that was it for 4. Yeah.
Great. Thanks, Aaron. Mr. Brown.
Thanks. Webb Brown, Montana Dental Association. Again, doing double duty here, but the Board of Dentistry at the meeting, I'm also monitoring at the same time here, did just agree to bring forward the dental hygienist compact as an issue at their next board meeting for their potential recommendation. And they actually heard a presentation earlier today on the combination of license tests at the national level, which would potentially make it easier for that to move forward. Bottom line for us is what's it going to cost for participants if Montana were to decide to join that compact. So I suspect we'll have something in the future, but there's no recommendation. Obviously, I think we should move forward with at this time on that specific compact. Thanks.
Thank you. Ms. Narison.
Thank you. So I'm speaking on behalf of the psychiatrist and the AMR, which is the EMS. They didn't get a chance to look at everything in great detail, but did feel like these 3 are probably bigger initiatives that need to be addressed, like more board by board versus something that the stakeholder group does as a recommendation, particularly with the compacts. I feel like the EMS compact is a pretty non-controversial compact, but I know that there are others that stakeholders feel very differently about those compacts. So I would be a little concerned about doing a blanket statement that we as a whole support compacts when some are bigger issues for boards than others.
Thank you. Any other questions or comments? Ms. Anderson.
Apologies if I'm garbled. I'm outside of Townsend. But Montana Primary Care Association represents a bunch of employers of healthcare licenses. And typically in the legislature, we've always gone in and supported compacts because the purpose of a compact is an established credential, usually national standards, multiple states participating. And so for me, I haven't met a healthcare compact that I didn't like, just for the purposes of recruiting and improving our workforce accessibility. So I don't know where that falls in these buckets, but I would just say that if we go back to a board by board assessment, you suddenly run into some various questions around protectionism, and I worry about that quite a bit. And I think we would, I don't know, I just support compacts in general. Thank you.
Ms. McCauley.
Hi, thank you. I would piggyback on what Miss Anderson said. I think it looks at expanding access. It looks at making more availability, increasing competition within the field. I think is always a good thing and reduces protectionism. And I would be in support of a broad statement for all compacts that are brought to us that have defined and that clearly nationally many other states have also agreed that it is a benefit to these rural states and many states that we would also support those initiatives. So I'm in support of a broad compact recommendation. Thank you.
Thank you. Dr. Harrington.
Yeah, I just want to echo what everybody else has said. And Ms. Anderson, I'm very much in support. So ditto for me.
Mr. Lloyd.
I just have a kind of a question slash recommendation as we navigate this. I think A is a great example of something that is good for those where there is a compact that exists. And then B is like the next level to me. If there's no compact, then B makes a lot of sense. The other thing that I would just like to ask Aaron is if we could possibly work these two things into the Sunset Review Committee. I think it would be valuable if we're doing some sort of regular review of licenses in the future, that these be two things that are considered in that process.
Thank you, Mr. Lloyd. Great point. Representative Buttrey.
Thank you, Mr. Chair. Just want to remind everyone that, our real charter is to remove barriers and to get people working in these occupations as quickly as possible. Certainly in healthcare, compacts are a big deal, and it does allow people that already have licensure within the compact or other states to get to work. So I definitely support 4A. I think 4C, well, back to 4A, if we have a occupation that does not have a compact, that's really when substantial equivalency comes into play. Again, allowing people to get to work quickly. I also like 4C because if we have duplication of efforts between what the state does and what a national certification does, why are we holding up people getting to work by requiring that they duplicate that effort in the state of Montana? So I support 4A. Where there are compacts, I think we should consider them, even though I know ones like the nurse practitioners can be contentious, but I think it gets people to work. If we don't have compacts, we need to make sure we have a robust substantial equivalency process, which I think we do. And then I also support 4C. So it's kind of a combination of all of them, but I think this can make a really big impact on getting people to work quicker, especially within our healthcare occupations.
Thank you, sir. Mr. Jensen.
Thank you, Mr. Chair. If there was a motion to recommend 4A, I would be in full support of that. The board that I'm associated with does not have any compacts at this point in time, but it is something that we are looking into and hopefully working towards. It's going to take us a while, I would imagine, but I would support 4A for sure.
Mr. Jensen. Ms. McCauley, another comment?
Thank you. My passion for 4A is clear, and that's in my statement before, but not to overlook that 4B and 4C, I both support both of those as well. Thank you.
Any other comments? All right. Well, hearing none, I guess I'll just do a simple motion. I'm not sure it's as clear cut on this one, but I would make a motion that we recommend adoption as recommendations for the full committee for A, B, and C as they're presented today.
Second.
Any discussion? Ms. Nerson.
This is just more a procedural question. I don't want to be, I don't know if we're really like making a record, but I feel like for both EMS and psychiatrists, they're not necessarily in opposition or in support. So I guess we would be in no position if that's allowed.
Yeah, of course. Mr. Lloyd.
Just a question. I personally don't like C. I would vote against anything that includes C. I just think that it is taking away the state right and giving it to somebody else, and that just doesn't feel right to me. Supportive of A and B. And so just if I vote against the motion for all three, I just wanted to be clear on why that was.
Ms. Anderson.
I'm just wondering if it makes sense to segregate the question, Mr. Chair.
Yep.
The motion, sorry.
Thought. Yeah. So, Mr. Jensen.
Yep. I was just going to ask if you could separate the motion into three different motions.
Yep. I'll withdraw my original motion. And then I will move to adopt recommendation. What is it? Is it just one C is the general support for
4A?
Or yeah, 4A. So yeah, so 4A to adopt a recommendation from the subcommittee that they're generally supportive of compacts. I'll make that motion now. Thanks.
This is Kristen McCauley. I'd like to second that.
All right. Discussion on 4A. All right. May not be unanimous this time, but we'll still just do a voice vote. All those in favor say aye.
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 Opposed? All right. Hearing none. I will make a motion to recommend this subcommittee adopt 4B and recommend that to the full task force.
This is Alan Lloyd. I'd second that motion.
Discussion? All those in favor say aye.
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 Opposed? All right. Moving on. I will make a motion to recommend option 4C to the full task force as well. Any second?
Doug Harrington, I'll second.
Discussion. Ms. McCauley.
Yes, in the cons, it talks about removing a state license. And I guess the way I read this and had understood this is it removes the duplication where certification exists, but it doesn't remove any licensure. Am I misunderstanding that?
If I could, Mr. Chair.
please.
So this recommendation gives several options. And so basically it's recommending that staff do an occupation by occupation review to identify, which we've kind of done that already, but to identify what occupations fall into this bucket. And then this it says right here, the subcommittee could recommend removing the license, converting it to a registration, or streamlining the application. So there's some options. It's not saying if this occupation is only needs a national test, then there won't be a license or anything like that. So there's a variety of things. I would probably recommend streamlining the application, streamlining the process in that case, or as we talked about in the last meeting. Making sure that the language includes or successor if the certifying entities are still going to be in statute. Because there's an example right now of a couple of certifying entities that have gone through a name change. And so that requires a statutory change if the name change doesn't say or successor, or if the statute doesn't say or successor, or consider replacing all of the named entities just to avoid confusion with defined criteria, such as an approved accrediting body or approved curriculum. So I think there's a few options on this. It's not saying that just because there's a duplication and and it's all national certifying bodies that we're looking at for these qualifications that there is no license necessary.
Thank you.
Light.
So does that mean
Oh, sorry.
that making this recommendation, it just leaving it open for how that reduction of duplication is implemented?
I'm sorry, can you restate that?
Yeah. So then this motion would generally be just reducing the duplication and then leaving it up to kind of how it falls out in with that as its core consideration.
Yeah, I believe so. I think this is a simplicity and a kind of a streamlining recommendation. Again, if you want some more analysis on this, kind of like we did for whatever 3C was, I don't know, I take terrible notes. Um, then then we can certainly I can do some more work on this and we can talk about it at the next meeting if this is confusing as it's presented today.
Thank you. I think that answers what I can go with.
Mr. Lloyd.
Chair Strauss, I just wanted to report that after the additional explanation, I'll be voting in favor of it. So just in case nobody votes against it, I didn't want you to wait for me there.
All right. Any other discussion? All right. Seeing none, all those in favor of the motion say aye.
Aye.
Aye. Any opposed? Heard one there. It sounded like. So my motion passes. I didn't hear opposition on the first two. So if there is anyone that wants to make sure that their positions reflected in a record, if there is one created, I would just recommend reaching out to Aaron to make sure that that position is clear.
Yep.
All right, Aaron. Do we have any
Okay.
more underneath this section, or one more?
Nope, that was 4. So the only other one that came out of the last meeting had to do with emerging fields and stackable credentials, alternative pathways. And so there was a brief discussion on that. The discussion did focus on community health workers, insurance reimbursement, medication aids, CNIs, and all of that kind of stuff. So Quinlan, I think, was the one that kind of took the lead on this about how there is an opportunity to maybe kind of work on some sort of stackable credentials type thing for emerging fields. This is just recommending that that there be a further study of this concept because it is very nebulous right now. And so recommend further study of whether Montana should create baseline or voluntary credentials that support reimbursement, workforce progression, and public accountability without unnecessarily restricting practice. And so that's really what it is at this point, just based on the conversations that we had at the last meeting. So, and I don't know if this really needs to be a recommendation for the task force or maybe just instruction for me to come back with a more details and stuff to discuss maybe at the next meeting.
Thanks, Aaron. That was my question. I wasn't involved in the last meeting. I apologize for being absent, but yeah, so I would leave it to the committee if whether or not this is something that they think is appropriate to escalate to the full task force or take it back to our next subcommittee meeting for more discussion. Representative Buttrey.
Thank you, Mr. Chair. I'd recommend that we do further study, maybe even in conjunction with the Healthcare Subcommittee. I think when we're talking about temporary or what's the word, voluntary credentials, that's going to cause a big issue in the insurance world, whether it's commercial or government. So I think there's more discussion that needs to be had before we could make a recommendation to the full board.
Thank you, sir. Any other comments? Is this the type of thing, Aaron, that we would want to like earmark for the full to make sure that the subcommittees are coordinating, or is that something that you do kind of separately behind the scenes?
No, I would ask that you discuss it during your presentation on Monday. Just say that this is something that we're talking about, and then I'm happy to coordinate with the healthcare subcommittee as well. I can connect the co-chairs, and you guys can decide how you want to move forward. If you want to assign it, reassign it, work on it together. We can do. And I know everybody loves Friday meetings, and so we could probably find another Friday morning meeting for both committees. Just kidding.
Perfect. All right, having heard that, I think that's an appropriate next step from my perspective.
Okay.
Unless there's any objection, I will say we'll move that as a comment for our report out on Monday, and then await further direction on how we approach it in the subcommittees.
Great. And I will say that I think hopefully there will be some discussion around this type of thing at the meeting on Monday, because we are dedicating several hours to healthcare workforce topics. And so my hope is that this may come to light and everybody will be excited about moving forward with it. That is all for this. Oh, here's just it. Yeah. Decision matrix. Love the charts. So I think I have good instruction on what recommendations to produce for Director Strauss and Representative Secondger's presentation on Monday. So we can, we can be done with this topic.
Great. Then moving on to the agenda, this one, Aaron, I think you offered to take the lead on presenting this, so I'll leave it to you.
Okay. Thank you, Mr. Chair, members of the committee. So the way that your work plan is set up is that there's basically two topics that you chose that we're trying to address at each meeting. In the interest of time and everything, I'm kind of trying to combine them where I can. And so for this meeting, we were scheduled to talk about potential barriers for that have to do with training, education, scope of practice, workforce shortages, and service access barriers. So I provided, where is it? There it is. I provided a memo for you. If you had a chance to read it, then great, and thank you very much for reading through it. But basically what this does is it just kind of combines some licensing analysis of Montana with other states that have to do with training, education, scope of practice, that thing. And then I also combined some of the public comments and recommendations, especially Ms. McCauley's had brought up a couple of topics that are directly relevant to this topic. And so there is what it says is that, stakeholders have identified shortages or actual or perceived shortages in behavioral health, rural emergency medical services, medical laboratory science, appraisers. There's a whole slew of things. And that there is a difference between true workforce shortages and administrative or regulatory bottlenecks. And so this memo just focuses on a few of these things. And then I came up with some themes that I can go through just briefly. So workforce access concerns are most acute where licensing intersects with rural practice. And so there have been a lot of comments and concerns about the rural workforce. And so there's some examples in here. And then some barriers are administrative rather than substantive licensing standards. And so application exam delays, that kind of thing. Supervision is a recurring bottleneck in behavioral health and other candidate license models. And so I think if you've been on the healthcare subcommittee, then that has been brought up as well as far as supervision and the qualifications for supervision. Let's see here. Stakeholders are divided on deregulation. And so nobody wants to eliminate the licensing, but we want to make sure that we have a right touch. Education cost and training may be larger barriers than licensing fees. And so I don't know if that's really a problem that this subcommittee can solve as far as the cost of education. But that has been brought up. And let's see, national certification, we talked a lot about that in our last topic. And so these ones are directly related to Ms. McCauley's comments that she's provided, is that degree title requirements may unintentionally limit access and oversight, and competency may be a better measure. And then facility-specific scope rules could leave gaps in certain areas like correctional group home or other non-traditional care settings. And so the next part of the paper talks about how Montana, like other states, use continuing education, supervision, all of these, tools and procedures. But there are some differences between states that Montana could look at as examples. So I just did the neighboring states, so Idaho, Wyoming, Colorado, Utah, and Oregon. And then there's some references in here that you can look at if you haven't had a chance, but just going through the takeaways. So Idaho, you could use that as the test model. So for supervision, education, and training, and all of these things, ask whether the rule addresses a present and recognizable public safety risk and whether a less restrictive alternative would work. This does tie into the sunset subcommittee's work that they're doing as far as evaluating criteria for a potential sunset review. And so this could be addressed within that committee as well. And Wyoming, North Dakota, and South Dakota use profession-specific models. So rural workforce issues could be addressed through targeted professional rules, supervision standards, or compact-related safeguards. Colorado has competency and experience. I can't remember what they call their model, but you could adopt the same concept to rural oversight. And then Utah, Oregon, and Washington actually do all of their stuff within rulemaking. And so many access barriers can be addressed through board or program level review rather than creating new new statutory requirements. So there are some policy options for consideration on these that I think there's 6 of them. And so similar to the last paper, for each of these options, there's kind of a little description and then pros, cons, and other considerations. Since this is just the introduction to the topic, I don't know if you necessarily need or want to adopt any of these options, but you certainly could if they seem kind of clear cut and common sense.
Thanks, Aaron. It looks like Ms. Narison, you have a comment?
Yes. If my understanding is accurate or correct, or I guess my ask would be to not vote on these today. other than to have a larger discussion on them at a future meeting.
Yeah, I think that's the intent for sure. I mean, my recommendation or comment would be, and to be fair, I haven't had a chance to review these in great detail, but I would recommend that we offer these up as a poll again, Aaron. I think that seemed to work pretty well, to gauge the subcommittee's interest in wanting to pursue these a little bit more, and this might give us a good fodder for the remaining committee hearings that we have on if there are ones that are overwhelmingly of interest of the group. So that'd be my recommendation. Any comments on that regarding from the committee? All right, seeing none, hearing none. Aaron, does that work for you?
Yes, Mr. Chair, that is fine. I can come up with a poll for you all. And then I'm just going to pull up your work plan. Where is it? Where do I have everything? Here we go. So your work plan, if I can get through here. So here we are, June 5th. So we do have 2 more meetings. And so this is just beginning this topic, identifying further issues. I'll do the poll and then for the next meeting can share the results of the poll like I've done with some of the other subcommittees. Is I would like to be able to share the results a week ahead of time. I know I normally send the documents like 2 days before, sorry. That's just kind of how it goes. But for this, I would want responses from the poll as soon as possible, and so I can prepare the summary and everything like that, and provide it to you all a week ahead of time, so you actually have more than 48 hours or less to digest it. So that would be at the July meeting, and then just so you're aware, these are the two. So rural and geographic barriers is kind of within this workforce shortages. And so I think that the reentry related barriers is really the only other topic that we'll have that's new to discuss. So we can do follow-ups on all of this stuff that we talked about today, and then something regarding reentry related barriers. And then you've addressed all 8 of your topics that you wanted. So I'm fine with that. But I would want I would ask for this for when you get the poll, which I could probably get out to you today. Try to respond as soon as you can, read through the stuff and all of that, but respond in the next week or 2. And so I can get a summary prepared ahead of time.
That sounds great to me.
Okay.
Any objection, comment on that? Perfect. Thank you, Aaron.
We have
Oh,
one.
sorry,
Yeah.
Dr. Harrington.
That's okay. Aaron, can you make sure I get copied on the email as well as Director Brereton, because I frequently am short noticed. So,
Okay. Yes. I will.
okay.
I will add you to my distribution list.
Thank you.
Mhm.
All right, moving forward on the agenda. Any outstanding issues, further issues, instructions to staff? I have none. I think you have plenty on your plate, Aaron.
Okay.
All right, seeing none. So as Aaron just said, our next meeting is Friday. Well, the full task force meets on Monday, so looking forward to seeing all of you there. And then our subcommittee will meet on Friday, July 10th at 9 a.m. and then have an outstanding future meeting on August 14th. Any comment on that? If not, I'll move forward to public comment.
You could go ahead and read that statement.
Yep. Okay. So the subcommittee now offers the public in attendance an opportunity to comment on any public matter under the jurisdiction of the subcommittee that is not on the current agenda. The subcommittee cannot act, but will listen to comments and may ask staff to place the issue on a future agenda. The chair may limit the comment period to proceed with the subcommittee with the subcommittee meeting. So with that, we'll open up to public comment.
I don't see anybody raising their hand, Mr. Chair.
Great. Makes this easy. So any other comments or directions from the subcommittee? All right, seeing none. Thanks. Have a great weekend.
Thank you all. See you Monday.